Jonathan, go ahead and
Hello everyone, thank you for coming. Mine's on the same thing, erroneous eyewitness testimony, and I had some of the similar questions. What do witnesses do, even though they feel confident? Because I found it interesting that some people can still give erroneous eyewitness testimony and yet feel very confident in testifying. And then also the authorities as well, and then what is being done with this phenomenon as it is now. So reasons for it were some of, like what my peers said. You could be fear of losing your credibility or your case being dismissed if you're a victim because you would like to get justice, so you would hope that you would get it passed and not case dismissed because you can't identify someone. And there's also recognition versus recall, which is where you try to fill in the blank of what you can't remember with little things instead of not completely recalling it. And so that's where we get a lot of our problems as well. And as my peers said, cross-racial mismatch, which in one of the studies they found that at 74 different exonerations this was happening, and that 44% of the time Caucasian individuals have a hard time identifying African American individuals, and I found that very intriguing because that's almost half of the time. There's also another thing called confirmatory biases, where we have our own biases going in and we try to fit people to them based on maybe race or dress, and basically judging a book by its cover and not actually looking at if that individual may or may not be innocent. And this happens when you have a lineup and there's an absence of the actual perpetrator, but you pick someone out because it's simultaneously done. And you there's fillers where you have someone to look as much like the perpetrator, and you pick one of the fillers that fits your idea of what a criminal would look like. As far as authorities, there's the police district's agenda versus the victims, where police have their own agenda as well. The victim wants justice, and so would the police, but they also want to look good to the public, and especially if they want to move up in their career. So they may rush in figuring out who would be the perpetrator, and in doing so, they actually are not doing a great job finding the actual truth, as we said with the inquisitorial system and such. There's feedback as well, where the police will give their own thoughts on the person picked out in the lineup. So if you pick someone out and they feel like it is a good thing that you did, they will be like, well, we found that the blood type matches the same as this crime scene with the perpetrator you picked out, so then you feel more confident. And there's a last one is a show-up technique, and I put a picture here of an instance where it's occurred, and also within like Ron Cotton case, which is a very big case that we all might be aware of, and they actually had him come in during the time that the victim was there, Jennifer Thompson, and so it made it in her mind fill in the blank where he would be the actual perpetrator, and she felt more confident in it even though he was not, and he unfortunately went to jail for quite some time for a crime that he did not commit. Steps taken to prevent this eyewitness testimony in the US and the UK. Well, one of them that I found interesting was that the Supreme Court recently heard Perry versus New Hampshire in 2012, and the Supreme Court 8-1 found that actually it was that the police were doing the right thing and they weren't giving wrongful feedback, and so it stuck more with the police instead of figuring out how to fix the system and make it better, which I thought was quite sad. And then the UK, which seems to be much more progressive, had in 1976 a case as well where they decided that instructions should be given to the jury to better educate them, that the testimony being given may actually not be all that accurate, and it helps to educate the jury more so. As someone said earlier, that they're not always professionals and we don't know ourselves, everyday person, so it's great to give them more information. The other thing that's being done more locally is the Illinois Capital Punishment Reform Study Committee, and they've given some of their own suggestions, doing instructions, and also having blind administrators, where it's double blind, where the administrator, the person there giving the lineup, doesn't know as well who the perpetrator is or any of the information involving it, so that way it prevents such thing as feedback, so that you actually know more of your own ideas and you're not filling in the blanks with other things. And then in the UK, they have the Devlin Committee's report, which was again in 1976, following the Turnbull directions, and they found some of the same similarities, but they actually put it into effect and had it passed, whereas here we did not put those into effect. We more so took it as suggestions than actual something to actually follow every day. Thankfully, some states have passed such things. In New Jersey and in North Carolina, they have, in North Carolina, the Eyewitness Identification Reform Act of 2008, which also has some of the same things about, instead of having instead of having simultaneous lineup, they have sequential, which is one at a time, because they found that when somebody sees one at a time, they're less likely just to pick someone out because it's a filler or such. So you'll actually may not just pick anyone out, which is fine, because it's better than just picking out the wrong person. Another thing was in the UK, they have the Police and Criminal Evidence Act of 1984, and they had, or Police and Criminal Act, and they had the Code D, which they updated in 2011, and this does some of the same things as well, but it holds it more into actual policy and keeps it there. The last thing I found was some things as cognitive interview, which is enforced. And like I said here, some things are suggested, but they're not enforced, especially federally. So that was some of the things there. And cognitive keeps you from getting the wrong information. And so what I asked last was, what does this mean for Illinois? What can we do? And other outlets and organizations to turn to. Thankfully, there's the Innocence Project and advocacy groups like that trying to prevent this. And the best thing we can do is ourselves, get the media involved, get more educated, and try to promote these changes. So thank you for your time, and I hope you learned something.
Your name is Jonathan? Is that correct? Okay, Jonathan, Erica, wonderful job. I just wanted to say, as someone who studies eyewitness memory and has attempted here in Chicago to have judges allow my testimony, well, the lawyers have attempted this, sometimes unsuccessfully. I think you did a wonderful job, both of you, of pointing out so many of the differences between the UK and Chicago in particular, what we can learn from the UK. And I guess to give some hopeful news to the audience here, as you pointed out, it doesn't look so great for Chicago here, but hopefully with the wonderful work that Katie and Phil are doing and others around the country, we'll follow footsteps, maybe like New Jersey and Oregon. Their state Supreme Court just came down with a decision, maybe some of you might have heard just a few days ago, saying that despite the fact that the police, and as you mentioned in Perry, the U.S. Supreme Court case, despite the fact that the police is really what we're going to be concerned with in terms of did they commit any misconduct in the identification, this new ruling in Oregon is going to open it up so that they look at what about if post-event information, as Erica mentioned, is present, or misinformation, and look at some exciting new things. So I hope that maybe some of these people will listen to your talks one day and open their minds some more, but great job.
They're welcome to, right? Certainly not.
I think you guys, first of all, both did a fantastic job, and I will probably say this numerous times over the course of this proceeding, but it's really exciting to see you all learning about these issues and getting excited and fired up and offended by a lot of them, as we have been. So I really enjoy watching you guys get involved in this. What I noticed is that you both identified that often the policy will be good, but the implementation will not be good. And I was just wondering, and I don't expect you to have an answer to this, but if you thought much about why there is such a lag between reform and compliance, and what we can do to narrow that lag, specifically in Chicago or in general.
Well, one thing that I always find interesting is the fact that we're much more doing it on local levels or state level, and it's very hard because it's not federally done. And in the UK, much of what they've done, even though they have 4 different, some smaller countries in a way, but in England and such, in Wales especially, they follow a lot of the same common law. And once it's implemented throughout the whole country. And I think that's one of the biggest issues. And seeing how the Supreme Court recently heard something and yet favored the police makes it more contradictory because it's making it so it's not being, complied with. So.
I just echo everything that Katie said about how exciting it is to see young people who are, already learning about this. You're light years ahead of, your peers. This is stuff that I just learned, like weapon focus. I just researched that for a brief the other day, and it's, groundbreaking stuff that you guys are studying. And just to piggyback off of what Jonathan just said, I think as far as, implementing this stuff on a federal level, it's really up to lawyers like myself and everyone else who cares about these issues to make this a matter of due process, so that the U.S. Supreme Court has to deal with the matter of whether someone has a due process right to present an expert witness to explain how difficult it is to identify people from a lineup, or how easily it is for someone to misidentify someone. At the very least, we should have instructions like New Jersey and Oregon are progressing on that front. But again, great job. Thank you.
Okay, so now we're shifting over to there's three that and your presentation is already up there. Chelsea, if you can just exit out of that. I'm going to group together the next three that all deal with either interrogative techniques or false confessions, since those are so related. So